I had been accepted at the University of Virginia, which I was really interested in attending because Virginia had a joint program in history and law where you could get both a master's degree in history and a legal degree at the same time.
And that was
1973. I entered law school in 1973. My class at Virginia was the first class that had, I guess what you would call a critical mass of women, which was 10%. I liked the environment. I liked the history courses I was taking tremendously. And I had had this experience my first year. They required that you write a brief and argue it in front of a panel of professors. And I had found that I had really liked that. And it surprised me because I had thought that I was more of an observer than a participant. And so I began to be a participant in the law school's moot court program. We started at the beginning of the second year and we worked our way through these arguments. And then, so by the end of the second year, we were still standing in this competition. And so at the beginning of the third year, then they start going outside the law school for judges. So we were pretty nervous. And of course, no woman had ever won that competition before. So we had that argument, and Sam and I won. Because of that experience, I thought maybe I should sort of see what it was like to practice law. And so I was sort of selectively interviewing with firms in Connecticut. I met Jim Wade from Robinson and Cole. He was a new partner there. He'd just been dispatched by his partners to find their first woman lawyer. I met him, I talked to him. He invited me to Hartford for more interviews, and I got a job for the summer.
So were you shifting at that point or not quite?
I think by the end of the summer, I was thinking maybe I would really like to practice law because I liked it a lot more than I had expected. I thought if Robinson and Cole would make me an offer, I would take it. And they did, and I did. And then I worked at Robinson and Cole from the summer of 1976 until the fall of 1978.
So as you began as an associate, were you getting into court often?
I had a case, an appellate case, involving a client whose son had been killed on a naval base in Italy. So they filed the lawsuit, and the lawsuit got dismissed. It was decided by people above my pay grade that we were going to take an appeal. And they let me write the brief. So the partners who were responsible for this case said, why don't you argue it? And I was arguing against an assistant U.S. attorney. They ruled against us almost immediately. But on that day in New Haven, Dick Blumenthal, who was the newly appointed U.S. attorney, was also making his first argument in the Second Circuit. And a couple of weeks later, I got a phone call from Dick Blumenthal. And he said that, he was trying to encourage young people in firms to come to the U.S. Attorney's Office for a period of time to get trial experience. And I told him I wasn't sure I was ready to give a 3-year commitment. And also I would like to continue to do some civil work because that was really primarily what I expected to be doing in my future career. And so I went to work at the U.S. Attorney's Office.
And this was
in
1978?
I started at the U.S. Attorney's Office in the fall of 1978.
Were you the only criminal assistant that was female?
Yes.
And
I was.
Also, I wanted you to address whether any of the agents that you were building cases with were female at the time.
No, most of the time that I was in court, unless I was in court with Judge Burns, I was the only woman in the courtroom.
I recall you telling me how you started small and then the cases became more and more complicated.
The way things worked in the U.S. Attorney's Office was you were in general crimes to begin with, and that's where I started. And so that included some drug cases. When Ronald Reagan was elected president in 1980, after he was in office for a while, the Reagan Justice Department sort of came 180 and decided they were going to do a big push in the war on drugs. And so they created OCDF, the Organized Crime Drug Enforcement Task Forces. I became the first OCDF lawyer in Connecticut, the lead OCDF lawyer in Connecticut. I tried the first continuing criminal enterprise case, which was a marijuana importing operation. I was in the Organized Crime Drug Enforcement Task Force until 1986. And then the person who had been supervising our Bridgeport office, Jim Pickerstein, went into private practice. And so I was named to be the head of the office in Bridgeport. And at that point, I started doing international money laundering cases and some illegal export cases.
So you became interested in applying to the magistrate judge's position.
I'd been in the U.S. Attorney's Office about 15 years at that point, 14 years, and I was starting to think about doing something else. And the Judicial Conference created another magistrate judge position in Connecticut, and some people on the committee began to encourage me to apply. And I wasn't that interested in the job, and so I had several days of talking to people about it. And I finally decided that I would take it. And the people who told me that it was a great job and would be fulfilling and something I could do for the rest of my life, they were right.
So now we're at June 1993.
June 1993. I was sworn in. It turns out that the job is probably 90% civil and 10% criminal. So I needed to teach myself civil law, and I needed to become acquainted with the techniques for doing mediation and settlement conferences, because those were things that negotiating was something that I hadn't done a lot of in the U.S. Attorney's Office.
And the skill set that you brought over from the U.S. Attorney's Office, how did that help you?
I was really surprised when I started interacting with lawyers, because the criminal bar in Connecticut is very, very collegial. The civil lawyers that I was interacting with when I became a judge were very combative. So one of the things that I tried to do was to make the civil practice in front of me more collegial. I did a lot of case management. I also did a lot of oversight of consent decrees. I ended up overseeing the consent decree for the women's prison, originally at Niantic. There was a consent decree for the prison at Summers. That gave me lots of insight into things I had never really thought about, like criminal justice reform, prison reform. I took over also the DCF case. It was really a great opportunity to delve into all kinds of areas of law that I had never had an opportunity to do much in before.
You should tell me a little bit about that, but perhaps get to the fact that you did retire and your status now as a recall judge.
It's like being a senior judge in that you can pick your work and you can pick the amount of time that you spend on it. You know, to come full circle, if someone had said to me when I was graduating from college, you're going to do all of these things, I wouldn't have believed it. I would not have expected to actually practice law. I would not have expected to like the law so much. I wouldn't have expected to be a criminal lawyer, and to find out that you could do so much good for so many people in that position as well as on the bench was a real revelation to me.